Thanks, Senator, for that line of questioning. And I've noted that you joined a letter with Senator Grassley and myself in March of 2020 at the earliest stages of this, talking about release under these similar circumstances. And of course, we all said at the same time, low risk inmates would be considered, but
Only low-risk inmates.
yes.
Yep.
And I wanted to make that note for the record. We're going to start the second round of questions, 20 minutes each, and I'll kick it off. This is an unusual document, this Constitution of ours, which has taken up so much time in the hearing, the conversation about it. And it is really at the core of public service. I don't know that there's a place that you can take a job at the federal level in any branch of government without taking an oath to defend this document. I don't know about other countries and the oaths that might be required, but we even within the Constitution spell out the oath to be taken by the President of the United States, and it's to uphold and defend this document. And there's great debate about just what this document means in today's context. We understand the wisdom, the inherent wisdom of the document, and the fact that we're still here some 230 years later with the design of a government that has endured longer than virtually any other democracy, which of course speaks to the wisdom of the founding fathers and their plan for this nation. But we also understand, taking an honest look at it, that you barely get into this document, Article 1, Section 2, then you run into a problem. Because in Article 1, Section 2, the article that relates to Congress, they talk about who will be counted for apportionment among the states, and there is that awful reference to 3/5 of all other persons, which, though the document never mentions the word slavery or slaves, what was being spelled out here by the founding fathers was, how are we going to count these slaves? And for apportionment purposes, they were to be counted as 3/5 of a person, which is a horrible notion by any standard, but the wise founding fathers included it, trying to deal with the reality of their day. I hear debates back and forth of originalists, textualists, and others, and you've been asked as often as any nominee what your thought is. You've talked about stay in your own lane, judiciary, and methodology and like. But I'd like to explore for just a moment, without asking you to get in any particular fact pattern, the reality of a couple things. First, when the Bill of Rights was written, the First Amendment to it made certain to guarantee freedom of press. Freedom of the press in 1790 was, of course, referring to a piece of paper, a newspaper, and saying that there would be freedom to engage in that process in this democracy of America. Now that freedom of press is referring to this, and things have changed an awful lot. We have a circumstance now where people no longer have just a handful of television networks or known publications, Washington Post, New York Times and such, but turn for their sources of information to places like Facebook and Twitter and beyond. And we have a real serious question about what is a publication in America? What does it take to be a publication and be press? Is my blog that I publish tomorrow the press, guaranteed with a constitutional right that I have a right to publish it as I wish, say what I want to say with certain boundaries? And I guess my question to you as we look at this is, how do you move from the language of 1789, 1790 to the reality of 21st century and make sure it's relevant? If more people are relying on Facebook and Twitter, for example, for information than they are common sources of television and newspapers, how do we rationalize that they can say, Facebook and Twitter, to a former president of the United States, you can't publish here. You're not going to be allowed to do it, and they've done that. So how do you reconcile that conflict of the changing times, the dramatic changes in technology, what the founding fathers envisioned and what we face today?
Thank you, Senator. the challenges that you identify are the types of things that the Supreme Court is now dealing with. We have a foundational document that has text and it has principles. It establishes freedoms and foundational important concepts that are intended to govern us and that we are bound by as a society. There's modern technologies, as you say, that have not that the framers, the founders could not have imagined the cell phone and all the other things that we now rely upon. And as I mentioned earlier, the Supreme Court and every court deals with individual cases, disputes about issues, and when the court gets an issue that requires constitutional interpretation, it looks at the facts and circumstances of the particular case and the text and principles of the Constitution in light of the times in which they were written and analogizes to present day. So the Supreme Court, for example, has considered the cell phone issue with respect to the constitutional principle of unreasonable searches and seizures, which is a protection from government intrusion that the framers called an unreasonable search. The text unreasonable search does not have an inherent definition. What the Supreme Court has done is looked back at the time of the founding to determine what kinds of intrusion would have been covered when those words were written into the Constitution. And to the extent that at the time of the founding, those words covered things like police officer intruding into your home and looking into your papers and affairs, then the Supreme Court analogizes that circumstance to the modern day circumstance of a cell phone, which now is in all respects, says the court, like rifling through your papers and affairs. So it's a process of understanding what the core foundational principles are in the Constitution as captured by the text, as originally intended, and then applying those principles to modern day.
I'll just give you two illustrations of my thinking on this and my frustration, or at least understanding of the challenge, let's put it that way. Senator Feinstein and I joined in legislation several years ago to talk about confidentiality of sources for news entities and whether or not a reporter could be compelled to disclose those sources. The effort really drew some of the best and brightest in the news business to come testify for the committee. The effort failed and faltered over what is a publication, who is a publisher, who is in the business of dispensing news. Does it involve money has to pass between them for this to be an official publication? Or can I just put up on my blog what I wish and resist any efforts to discover my sources? That was one of the serious issues that we faced. We also took a look, I take a look at where this is going in terms of the future and our entities that we rely on for news so often. And I'm going to leave it at that because I think you've addressed the general and don't want to get into more specifics, nor should you. But when people pledge that, they are originalists, we're sticking with the original words, you better have your mind open to the reality that this world is changing and changed, and many of those principles are sound today, but the challenges of interpreting them with the reality of today's technology is a challenge, a very difficult one, which you would face in the court. I'm going to try to set an example here We have 20 minutes, and I'm going to try to yield back some part of it. I see that Senator Cornyn is here, and I'm glad he is, because I'm going to address an issue which he raised yesterday and again this morning. And I wanted to do it while he was physically present, so that when he gets his turn, he can address it. I'm sure he will. Yesterday, Senator Graham said that you had gone too far in calling the government, quote, a war criminal and pursuing charges against a terrorist. Later, Senator Cornyn asked Judge Jackson, I quote, you referred to the Secretary of Defense and President of the United States as war criminals. Why would you do something like that? As I noted yesterday and repeat this morning, these charges don't hold up. CNN fact check said, quote, both Graham and Cornyn left out important context. Specifically, neither mentioned that Jackson's allegation of war crimes was about torture. Also, Jackson didn't explicitly use the phrase war criminal. The New York Times noted that the allegation, quote, is a distortion and lacks context. The New York Times went on to say, Judge Jackson did not specifically call the former president and defense secretary war criminals. She was one of several lawyers in 2005 signing 4 essentially boilerplate habeas corpus petitions on behalf of detainees at Guantanamo that claimed the U.S. government had tortured the men and that such acts constitute war crimes, that's in quotes. The petitions each named Mr. Bush and Mr. Rumsfeld, along with 2 senior military officers who oversaw the Guantanamo detention operation in their official capacities as respondents. Washington Post noted, and I quote, one key thing to note, as law professor Stephen Vladeck does, is that Bush and Rumsfeld are named in petitions because they have to be, to clear procedural hurdles. Indeed, those petitions later named Barack Obama after the administration changed. Another is that they are named in their official capacities, not because of actions they personally took as individuals. They continued, but the larger point is that Jackson was acting as a detainee's lawyer in her role as public defender, and one of the underpinnings of the American justice system that is even the most reviled alleged criminals have the right to a vigorous defense. Would you like to comment on that statement that I just made?
Well, Senator, I would just say that public defenders don't choose their clients, and yet they have to provide vigorous advocacy. That's the duty of a lawyer. And as a judge now, I see the importance of having lawyers who make arguments, who make allegations. In the context of a habeas petition, especially early in the process of the response to the horrible attacks of 9/11, lawyers were helping the courts to assess the permissible extent of executive authority by making arguments. And we were assigned as public defenders. We had very little information because of the confidentiality or classified nature of a lot of the record. And as an appellate lawyer, it was my obligation to file habeas petitions on behalf of my clients.
Thank you, Judge. I'm going to try to set an example by yielding back about 7 minutes of my time. I invite my colleagues to follow that example if they wish. Senator Grassley, you're next.